A former governor of a Nigerian state has been held in custody for over 32 days. No charge, no arraignment, no court date. Not accused before any judge, not given the opportunity to enter a plea, just held. And here is the question that nobody in mainstream Nigerian media is asking directly. If the ICPC genuinely had a corruption case against this man, why has it not walked into any court in Nigeria and presented it? The silence around that question is louder than anything the government has said. Today, the ADC, the party this man defected to, has publicly told President Tinubu that what is happening has a name. They called it a drift toward dictatorship. We are going to examine whether that word is justified or whether it is political theater, because the answer to that question does not affect one politician from Kaduna, it affects every single Nigerian. Stay with me. Before we go further, if you're new here, Naija Update 24/7 exists for one reason: to give every Nigerian, wherever you are, whatever region you are from, the political analysis that mainstream media won't touch. Hit subscribe and stay with me. This gets deeper. To understand where we are, you need to understand the sequence of events, because the sequence is everything. About 32 days ago, Nasir El-Rufai, former two-term governor of Kaduna State, former minister under President Obasanjo, and one of the men whose political networks helped deliver Tinubu's presidency, honored an invitation by the EFCC. He went voluntarily, in good faith. He was released. Then within 2 days of that release, he was taken again, this time by a different agency entirely, the ICPC. And from that moment to this day, he has remained in custody. No arraignment, no formal charges before any court, and according to his own account, the conditions of that detention have included being cut off from his family, denied access to his personal physician, and, this is the part that should stop every Nigerian cold, alleged pressure to abandon his political choices as the price of his freedom. Let that land for a moment. Alleged pressure to change his political affiliation in exchange for release from custody. On the 2nd of March 2026, the ICPC issued a public statement saying it had received a petition accusing El-Rufai and officials of his administration of financial misconduct between 2015 and 2023. That is 8 years of governorship. The petition is broad. The investigation, they say, is ongoing. El-Rufai has since filed a fundamental rights enforcement suit at the FCT High Court. He is asking the court to declare his arrest and detention unconstitutional and unlawful. He is asking for 1 billion naira in damages. The ICPC has filed a counter affidavit. So the matter is now before a court, but he remains in custody while that court processes the case. Now, why is this happening in March 2026 specifically? Because in the months before his detention, El-Rufai made 2 moves that, from Aso Rock's perspective, crossed a line. First, he formally defected from the APC to the African Democratic Congress, the ADC. He did not just submit a letter, he went to his ward in Ungwasaki in Kaduna, registered publicly, and brought his political associates and former appointees with him. It was a declaration, a visible, deliberate break. Second, and this is important, as far back as September 2025, El-Rufai stood before cameras and said, on the record, that the Tinubu administration poses a greater threat to Nigerian democracy than any military regime the country has ever experienced. He warned that if Nigerians do not end this administration at the ballot box in 2027, Tinubu would attempt to become Nigeria's version of Paul Biya, Cameroon's president who has been in power since 1982. He said all of that publicly before his own detention. Here is the historical context you need to hold. El-Rufai was not a peripheral figure in Nigerian politics. He was a minister under Obasanjo. He governed Kaduna for 8 years. He was reportedly on the short list for a cabinet position under Tinubu, before his name, according to multiple reports, was quietly removed. The fall from central insider to detained suspect in under 3 years is not a small story. It is a signal. Later in this video, I will show you the specific constitutional provision the government appears to be violating and why no judge has yet issued an order stopping it. That answer is not what most people expect. Let us talk about institutions, because this story is fundamentally about which institutions are working, which ones are being stretched, and which ones are under pressure to look away. 4 institutions are central to this story. The EFCC, the Economic and Financial Crimes Commission, was the first body to detain El-Rufai. They released him. Within 48 hours, the ICPC, the Independent Corrupt Practices Commission, took custody. That relay, one agency releases, another immediately picks up, is not accidental. it is a mechanism, and it raises a direct legal question. Can two separate anti-corruption agencies be used in sequence to extend detention beyond what any single agency is legally permitted? The NSA's office has also entered this picture. The ADC's public statement specifically named the National Security Advisor, Malam Nuhu Ribadu, alongside the ICPC leadership as officials expected to ensure constitutional compliance. That is a significant naming. Ribadu is a former EFCC chairman. His proximity to this matter has not gone unnoticed. And then there is the FCT High Court, the institution that, under the Constitution, has both the power and the obligation to act when a citizen's fundamental rights are violated. Now, what does the Constitution actually say? Section 35 of the 1999 Constitution, as amended, is not ambiguous. Any person who is arrested must either be charged to court within 24 to 48 hours or released on bail. That is the law. There is no clause that says, except during an ongoing investigation. There is no provision for what some are informally calling investigative detention that extends to 32 days and counting. A senior lawyer, Kenneth Okonkwo, addressed this directly. He said, and I want you to hear this carefully, 48 hours is what a government has to keep anybody in detention without granting bail. The whole idea of arrest is that you have concluded your investigation and you have found the person culpable for any crime you are alleging he committed. That is not a political statement. That is a statement of what Nigerian law says. So where is the government finding legal cover for what it is doing? The ICPC Act grants the Commission broad investigative powers. Over the years, certain court interpretations have read those powers widely, wide enough, some lawyers argue, to permit extended detention while an investigation is active. The government's position appears to rest on exactly that reading, that the investigation justifies the detention and that the court process El-Rufai has initiated is the appropriate avenue for relief. Here is what most Nigerians do not know about the ICPC. It is not the Nigerian police force. It was not created to hold citizens in pre-charge custody for weeks. Its statutory mandate is to investigate corruption and prosecute it, not to detain suspects while it decides whether it has a case. Using it this way is constitutionally unusual, and legal experts across the political spectrum have said so. The ADC put it plainly. Freedom under the Nigerian Constitution is not a privilege that the executive branch grants or withdraws at will. Rights are not subject to negotiation in closed rooms under pressure by agencies that ultimately report to the presidency. The FCT High Court can order El-Rufai's release. What we are watching now is whether it will and how quickly. I will come back to that before this video ends. Now, we get to the layer that explains why this is happening. Not the legal layer, but the political one. Who benefits from Nasir El-Rufai remaining in detention? Let us be precise about this. First, deterrence. El-Rufai is not a junior political figure whose detention would pass unnoticed. He has deep national networks. He has credibility in the Northwest and Northeast, regions that are critical to any presidential coalition in 2027. He has the capacity to raise funds, convene political talent, and build opposition structures. His detention, without charge, sends a message to every other APC heavyweight who is quietly calculating their options before 2027. The message is, the cost of crossing this administration is not just political, it can be personal. Second, disruption of the ADC. El-Rufai's defection to the ADC was not routine. He did not move quietly. He moved visibly with political associates in a way designed to signal that a genuine alternative coalition was being constructed. His continued detention disrupts that construction. He cannot organize from custody. He cannot recruit. He cannot build. And third, and this is the 2027 arithmetic, the ADC has explicitly said that Tinubu is using anti-corruption agencies as instruments against anyone perceived as a threat to his re-election agenda. That framing, whether accurate or exaggerated, has now been placed in the public record. Every Nigerian voter will make their own assessment. Here is the strategic irony that I want you to hold. The man now being held by this government is the same man whose political networks were part of the machinery that helped deliver this government's election victory. He helped build the coalition. He is now being held by it. And in September 2025, before his detention, he said on record that past Nigerian presidents, including Buhari, who came from a military background, never weaponized state agencies against political opponents like this civilian administration is doing. He said that before it happened to him. Now, who risks losing from all of this? The northern political establishment is watching carefully. El-Rufai's profile in the northwest and northeast is significant. Extended detention without charge does not sit quietly in that region. It generates sentiment, and sentiment in election season translates to votes. The judiciary has perhaps the most to lose. If the FCT High Court fails to enforce Section 35 of the Constitution in a case this visible, the message to every ordinary Nigerian who cannot afford lawyers, who has no public profile, who has no party issuing statements on their behalf, is that constitutional rights are selectively enforced. That is an institutional wound that does not heal quickly. And the APC itself is watching something that every ruling party eventually faces, whether loyalty to power guarantees protection or merely delays vulnerability. The ADC has said it clearly. Today it is El-Rufai. Tomorrow it could be anyone that the president perceives as a threat. The erosion of rights does not begin with everyone at once. It begins with one, and it spreads where silence allows it. That is the principle at stake. Not one man's freedom alone, but whether the Constitution of the Federal Republic of Nigeria is a document that means something, or a document that means something only when it is convenient. Now, if what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything. Earlier, I made you a promise. I told you I would show you how this situation maps onto a pattern seen across African democracies in the last decade, and what happened next in each of those cases. Here it is. What is happening to El-Rufai is not without precedent on this continent. The playbook is familiar. A credible opposition figure emerges, someone with real networks, real resources, real capacity to challenge incumbent power. Anti-corruption institutions, which exist for legitimate purposes, are activated against that figure. The charges are broad, the investigation is described as ongoing, detention extends, and the institutions that should intervene, the courts, civil society, the international community, move slowly if they move at all. We saw a version of this in Uganda when Bobi Wine was harassed, detained, and physically attacked by state security forces in the lead-up to elections. We saw it in Tanzania before the 2020 elections when opposition leaders faced systematic detention and disappearance. We are watching versions of it across the Sahel today, not through military coups alone, but through the quieter, more leaderly dressed erosion of political space. In each of those cases, the sequence followed the same logic. First, the visible opposition figure, then the institutional silence, the courts slow to act, the agencies defending their conduct, the ruling party issuing statements about due process, then the international noise, the diaspora communities, human rights organizations, Western governments issuing carefully worded statements, and then the domestic question, the one that determines everything. That is the question Nigeria is now being asked. Now, where do Western governments stand on this? As of today, no major Western government has issued a formal statement specifically addressing El-Rufai's detention. The United States has not spoken, the United Kingdom has not spoken, and that silence for now is itself a strategic data point. Here is why. The US and UK both have significant diplomatic and economic stakes in Nigeria. Nigeria is the largest economy on the African continent. It is the most populous black nation on earth. Western governments do not move quickly on these matters. They calculate. The U.S. State Department monitors Nigeria's rule of law conditions as part of its annual human rights reporting process. The UK hosts one of the largest Nigerian diaspora communities in the world, a community that is politically engaged, increasingly vocal, and paying close attention to what is happening at home. And this is the point I want Nigerians in London, in Houston, in Toronto, in Manchester to understand clearly. The way this story is framed internationally will determine whether Western governments stay silent or speak.
If this remains a corruption prosecution story, a former governor facing financial misconduct allegations from his time in office, Western governments have a reason to stay quiet. Accountability for public officials is a principle they support publicly. But if this becomes a fundamental rights story, and that is precisely what the ADC's public statement and El-Rufai's own court filings are constructing it as, the diplomatic picture shifts. A formal petition to Amnesty International, which the ADC has threatened to file, would place this case on an international human rights record. And once it is on that record, the silence becomes harder for Western capitals to maintain. Here is the detail that most people following this story have missed entirely. El-Rufai has not only complained publicly, he filed a lawsuit. He asked the Nigerian court to award him 1 billion naira in damages for the violation of his constitutional rights. Think about what that action means strategically. A man trying to escape accountability does not walk into a courtroom and invite judicial scrutiny. A man confident in his constitutional position does exactly that. He puts the question before a judge. He dares the system to answer.
The question before Nigeria right now is simple. Will the judge stand with the Constitution? Now, and this is the section that separates serious analysis from political cheerleading, let us hear the strongest case for the government's position, because it exists, and Nigerians deserve to hear it honestly before they make up their minds. First argument. El-Rufai governed Kaduna State for 8 years. 8 years is a long time. A lot of public money passed through that administration. Allegations of financial misconduct across that tenure are not inherently implausible. No former governor, regardless of their current political positioning, is above accountability. If the ICPC has genuine, documented evidence of corruption, then the public interest in prosecuting that case is entirely legitimate. That principle is not negotiable. Second argument. Complex financial investigations take time. The ICPC is not a rapid response unit. Tracing public funds across 8 years of government, across multiple agencies, multiple contracts, multiple officials, that work is slow. The argument that an investigation still being assembled cannot immediately produce charges in court is not an absurd legal argument. It has precedent. Third argument. El-Rufai is not a neutral figure. He has made extraordinarily charged political statements about this administration. He compared Tinubu to Paul Biya, a man who has held power for over 40 years. He publicly called for the Tinubu administration to be ended at the ballot box. He defected to an opposition party and began building what looks like an alternative coalition. Some will argue, reasonably, that a man who positions himself this aggressively in the political arena should not be surprised when political consequences follow, including scrutiny of his own record in office. These arguments are not without weight. I will not dismiss them. But here is where they all stop short of resolving the fundamental problem. The Nigerian Constitution does not have an exemption clause that reads, Section 35 applies to all citizens except those whose investigations are complex or whose political statements have been inflammatory or who have made enemies in high places. It does not say that. Section 35 says, charge him or release him within 48 hours. The ADC has made this demand with precision. Their statement said, we demand the immediate release of Malam Nasir El-Rufai or his immediate arraignment in a court of competent jurisdiction. Nothing more, nothing less. That is the law. Not freedom from accountability, not immunity from prosecution. Just follow the Constitution. And here is the national interest conclusion, the one that should matter to every Nigerian, regardless of which party they support, regardless of which zone they come from, regardless of whether they ever liked El-Rufai or not. Today, it is a former governor, a man with lawyers, a man whose name is known, a man whose party is issuing press statements, a man whose case is being reported by the media. What about the Nigerian who has none of those things? What about the ordinary citizen detained by a federal agency, no lawyers, no party, no press conference, who relies entirely on Section 35 of the Constitution as their only protection? If that section does not hold for El-Rufai, with all his visibility and resources, what chance does it stand for the Nigerian whose name nobody knows? That is not a northern question. It is not a southern question. It is not an APC question or a PDP question. It is a Nigerian question. And the answer will define what kind of country this is. So where does this go from here? Let us talk about next moves, because the next few weeks will be decisive. The ICPC is now in a position where the cost of continued silence is rising fast. National attention has intensified. The case is in court. International eyes are beginning to turn toward Abuja. The most likely path for the government now is arraignment. Bring El-Rufai before a court on formal charges. Transfer the battle from the detention cell to the courtroom. That does not end the constitutional damage already done, but it changes the optics. Watch for whether that arraignment happens and how quickly. El-Rufai's legal team, on the other side, will push the FCT High Court for a swift ruling on the fundamental rights suit. That court is now the most important institution in this story. Watch its calendar, watch its rulings. Judicial speed, or the absence of it, will itself be a message to Nigerians about the health of their institutions. The ADC has publicly threatened to take this to Amnesty International. That is not an idle threat from a minor party. If that petition is filed and accepted, El-Rufai's detention enters the formal international human rights record. From that moment, every Western government that has been silent must actively choose to remain so, and that choice carries its own diplomatic cost, particularly for a government that needs international economic credibility.
And Tinubu's political team is doing its own arithmetic right now. The calculation is this. At what point does the cost of keeping El-Rufai in detention exceed the political benefit? A prolonged, publicized court battle with international attention, diaspora pressure, northern political sentiment hardening, and APC governors watching nervously is more damaging to a re-election campaign than releasing a man who then has to defend his own record in a legitimate courtroom. Here is what to watch for in the coming weeks. Watch whether any APC governor makes a public statement, and note carefully those who say nothing. In Nigerian politics, silence from your own side is sometimes the loudest signal. Watch whether the US or UK missions in Abuja issue any communication, even something carefully diplomatic, even something that merely references rule of law concerns without naming El-Rufai directly. Watch whether other politicians who have been considering defection from the APC slow down or accelerate their timelines. Deterrence only works if people are deterred. And watch the northern political temperature. Sentiment in that region, quiet, slow-moving, but consequential, will shape the 2027 landscape in ways that no amount of federal patronage can fully reverse if it turns. The signal that would confirm this is escalating rather than resolving. If El-Rufai is formally arraigned on charges specifically designed to justify continued pre-trial detention, that would mean the detention continues but is now dressed in legal clothing. That outcome would be constitutionally worse than the current situation, not better. Nigeria is 27 months from a general election. The institutional habits being established right now, how agencies are deployed, whether courts enforce the constitution, whether opposition can organize freely and safely, will determine the quality of that election. This moment is not about one man from Kaduna. It is about whether the architecture of Nigerian democracy is being quietly hollowed out brick by brick, or whether the institutions built to protect it are strong enough to hold. Earlier in this analysis, I asked why no court has yet ordered El-Rufai's release, given what appears to be a clear constitutional violation. Here is the honest answer. It is procedural, not principled. Courts in Nigeria do not act unilaterally. A case has been filed, hearings must be scheduled, affidavits exchanged, processes followed. The Constitution is not self-enforcing, it requires the courts to enforce it, and courts move at the pace of procedure. But that procedural explanation does not erase the constitutional reality. It only means that when the resolution comes, it will be on the public record, visible, documented, and permanent. Every Nigerian will see what the FCT High Court decides, and that decision will say something about this country that will outlast this political moment, this administration, and this election cycle. So, is the ADC right? Is what is happening a drift towards dictatorship?
Based on the documented facts, a citizen held for more than 32 days without charge, alleged denial of access to family and medical care, alleged coercion to change political affiliation as the price of freedom. Two separate anti-corruption agencies used in sequence to extend detention beyond what either could legally justify alone. The constitutional case for serious concern is real. Whether the word dictatorship is precisely accurate, that is a debate Nigerians should have calmly, openly, and with full facts in front of them. But what is not in dispute, what cannot be argued away, is this: the Constitution is either enforced for everyone or it protects no one. That is the principle. That is what this story is really about. And that is the question every Nigerian, from Sokoto to Calabar, from Kano to Lagos, from Port Harcourt to Maiduguri, should be asking their government, their courts, and themselves. If this analysis gave you clarity, share it with one Nigerian who needs to understand what is really happening. Like, subscribe, and I will see you in the next one. Naija Update 24/7. We never stop watching.